Well, good evening. Hello, everyone that's in the room. We're just right on time here, getting started with the sixth panel and last panel of the AACE and DRBF 2023 Dispute Board LATAM Awareness Program. Together here with me, I have Elizabeth and Christian, which have a lot of experience to share with us here tonight on dispute boards. And our topic today will be chairing a DRB meeting. I would like to start this panel by presenting our panel members here, starting with Elizabeth. Elizabeth, she's recognized as an expert on dispute resolution in construction, environmental, and in energy areas. She has been appointed as an administrative law judge, arbitrator, mediator, special master, dispute resolution board member, and partnering facilitator for over 1,500 projects. Her background includes over 30 years of experience as an attorney, providing private general counsel, legal service to design professionals, contractors, and owners. She was appointed Northern California super lawyer for alternative dispute resolution from 2020 to 2023 and received the award for distinguished contribution to the field of mediation from the Mediation Society. She's known for thorough preparation, technical knowledge, exceptional listening skills, calm influence, and impartiality. Well, good night, good evening, Elizabeth. Thank you for being here with us. Would you also like to talk a little bit about your experience, which is, from what I said, pretty vast.
Yeah, thank you for the great introduction. My experience really spans from initially starting in design and then going to law school and focusing on construction law. And my first trial, I definitely decided this is not the way to resolve conflict. And so I've always been seeking opportunities to find economical ways for people in the construction industry to resolve conflict. And when I became introduced to dispute boards, which was when I was sitting as an administrative law judge and somebody presented a written opinion of a DRB, I was convinced. It's a great process, and I'm thoroughly happy of spending the time to training from the DRBF has been incredible, traveling around the world, speaking and training people on behalf of the foundation, and also serving as president of the Region 1 DRBF. So it's been a great ride, and I really love this process, and it works. Thank you.
All right, thank you. And also Christian, good evening, Christian. Thank you for joining us. Christian, he's one of the founding partners of Conexa in Costa Rica, director of the International Arbitration Practice, has an LLM in commercial law in the Universidad para la Cooperación Internacional, has a postgraduate diploma in international commercial arbitration at Queen Mary London University, and is an alumni of the ICC Arbitration Academy for Latin America. He's a mediator, dispute board member, and arbitrator, and also the country representative for Costa Rica of the Dispute Resolution Board Foundation. Well, Christian, would you
Hello.
like also to say a few words to our audience?
Hello. First of all, thank you for the invitation to being here. I'm excited practitioner of dispute boards. Well, yes, I have been involved in dispute boards, both as an attorney and as a dispute board member. I have represented a Spanish client in El Salvador in 2 dispute board processes. And in Costa Rica, I've been appointed to be a dispute member as an ad hoc dispute member, but also as a standing dispute board member. So I can talk about the differences about that also. And in Peru, I've been appointed for some projects as a standing dispute board member, which is something interesting because in those we start like in the middle of the project. So I've been, I think, in whole scenarios as an attorney, as a dispute board member, sole dispute member, with other colleagues, ad hoc and standing. So I think I have all the flavors of the palette. Yes, and it's very interesting and something that I enjoy a lot, because as a dispute board member, you're like a part of the team that is both parties together and the dispute board trying to help them to get the project done. So yeah, that's kind of my experience here.
All right. I'm sure it's going to be very interesting chat today. And well, I'd like to say also hello to our audience. I can already see on the chat people here saying hello, their names and where they're from. Please let us know. And if you would like to also send questions to our members here of the panel, please use the Q&A channel. And as we go forward, as the questions pop out, we're gonna address them. And of course, we're gonna spare some time to do that. I can see that we have a lot of participants from Brazil and South America and Latin America, where DBs are still, getting started. So I think we can start from the beginning, give an overall view to our audience, how DB members are appointed. Is there a preference? If lawyers and engineers, how are they usually engaged? Maybe if you could give us, your view on that, Elizabeth, from, how does the B start? And from that starting point, then we'll go on to see how it works and how the chairing, how it does proceed.
Well, I think that most dispute boards in the United States, Region 1, Canada, and the Caribbean are, it's kind of a retaining an individual versus something that may happen in the European arena or worldwide arena is they might be using the FIDIG list, or they might be using the ICC DRB list, dispute board list. So they might do a request to place 3 dispute board members, and that organization will put together a list. But I'll tell you, in the United States, it's pretty much the Wild West. So you have an opportunity to market yourself. So how do you do that? For me, getting the training, establishing your credentials. I'm a litigation attorney, but I've done a lot of arbitration and mediation practice. And so going into doing dispute board work, getting training at the Dispute Board Foundation was the beginning step for me. And then getting on lists. And I'll say one of the lists that has been a great resource is Caltrans, which is the California Department of Transportation. They do annual training, and they also establish a list and submit everybody's resume, et cetera. And that list is used by a lot of organizations, governmental and individual corporations, et cetera, to find dispute board members. So that's a great resource as a number one step. And that training is available to anybody in the world. So I know that they're getting a lot of people from out of the country that want to take the training, and it's, pretty difficult to get admitted to take the training. You have to establish your credentials in construction, ADR work, and construction information to get on that list, but it's a great first resource.
Very, very interesting. Christian, you have any words to add on that topic?
Yeah, well, I have a little comment to do before getting appointed in our countries in Central America, maybe from the experience that I have from Peru. It's very important what the multilateral banks have done in Latin America. For instance, in Central America, the International Inter-American Development Bank, what we call the BID, Banco Interamericano de Desarrollo, is asking the government states that get a loan for an infrastructure project to establish a feeding contract. And of course, within the feeding contract is the dispute board clause. So that had played a big role in our countries because most of the infrastructure projects are financed by these multi-development banks, and these multi-development banks are asking the countries to include the feeding and the feeding contract and the dispute board clause. So, and they are also encouraging the countries to start using the dispute board in an early stage of the contract. So, being said that, in Costa Rica, for example, the DRBF gave us a training like 4 or 6 years ago. So we developed in the Bar of Engineers in Costa Rica a training conducted by the DRBF, and we have like more than 50 dispute board members now in Costa Rica, duly trained by the DRBF here in Costa Rica, and people also came to those trainings from other countries from Central America. So that is very important to mention, that the training is very important, and the role of the DRBF in those trainings in Latin America is very important too. Okay, that's it.
All right.
Just to start.
Yeah, it's then if Anne's listening to us, if we can send it through the chat or then send to our audience more information of the links and where we can look forward to get this training. I think there might be a lot of people interested on that. But well, going to the topic of tonight, which is the chair. Well, getting the list and finding the members. When does the chair gets elected? Is the members, do they get together and elect, choose a chair among them, or how does it work?
So I'll just tell you from my perspective, the typically many times one entity, the governmental entity, the employer chooses one DRB member, and the contractor chooses the second DRB member, and the two of them get together and choose the chair. But more and more, there is an open list that both the employer and the agency and the contractor get together and put together a list of, say, 8 potential DRB members. And they might decide, between them, just in negotiation. And it's a great first negotiation task. They've gotten the contract and now they've got to choose who's going to resolve conflict. And so they choose, who are the 3 people that are going to be on the DRB, and they might choose who's going to be the chair also, although they might leave that to the participants. There's no standard procedure that happens in every particular situation. So that's left open, on the particular projects. And also, I want to just mention, because I've taken the FIDIG training for dispute boards in Europe, very long, multi-month training program. So I know that process, and it's much more organized than in the United States, whereas there are no specific rules. In the FIDIG arena, there's a lot more specific rules about how things are done. And so different attorneys write contracts for projects, which include a dispute board process, and that they may write the terms of how the dispute board members are selected, how the chair is selected. So it's, there could be a variety of processes. Christian.
Yeah, well, I agree on that, and the variety of process, and that also is related of the variety of contracts and the variety of countries. Like, for instance, in Peru, for the AACE contracts that I'm working with at this moment, they put together a list. And in that list of dispute board members, both parties negotiate between each other who are going to be the 3 members and who is going to be also the chair of the DV. That is that specific case. In Costa Rica, in the ones that I have been involved, one party choose one, the other party chooses the other one, and between the 2 chosen members negotiate to nominate the chair, like in Salvador, list in the Chamber of Commerce of El Salvador. So it will depend mostly about the contract, about the country, about the practices. So yeah, that is a good thing to say. But also, I just want to mention that in the dispute board world, we are not just lawyers, but also engineers, maybe architects. So some of the dispute board members will be not lawyers, but will be engineers or architects. So that is very important to understand, because that is one of the key points for a good dispute board member to work well, is to have both sides, the legal side and the technical side together, both with ADR, this alternative dispute resolution training, if possible, because it will be a mix of negotiation, mediation, arbitration, all that, all together with a DV. So it's very important to have this kind of training besides dispute board, but also mediation, negotiation, and arbitration.
And I agree. I want to just tag on to something about that, which is, a lot of times you think, should the chair be the most technical, knowledgeable person, or should it be the most legal, knowledgeable person? And I think the main context that I have is your dispute board, the 3 members, should be diversified. That they should have diversified backgrounds to really complement each other. There may be one who's had more experience technically with that type of project, say if it's a water project or a highway project. There may be one that has more technical knowledge, and there might be one that has more legal knowledge, so the contract terms and the specifications, etc. But it doesn't matter which person becomes the chair. Frankly, I like to see different people have the opportunity. The main thing about the chair is they have to be willing to do the administrative work that's involved in being the chair. You have to keep the ball rolling. And I know we're going to talk more about that, but that's my thoughts.
Can we say that's a little bit similar from the rule of the chair on a tribunal as well? When we have an arbitrational tribunal, the chair is centralize most of the task, and like you said, needs to keep the ball rolling. Can we do this parallel?
Well, my thought is that when you do arbitration, most of the time you're getting 3 attorneys. You're not getting an engineer. And the beauty of this process is that you include those people who have real technical knowledge and construction knowledge, that those people experience is included. And I think that makes this process unique and different than arbitration. And, that you're resolving conflict while the project is ongoing with real people that understand and have been to the site. And, so that's important. But selection of who the chair is can be different on each project. And it doesn't have to be the most technical, knowledgeable person.
Yeah, I'm glad that you mentioned arbitration because when I have the opportunity to say what I'm going to say in a minute, I always say that we need to take the arbitration chip out and put the DB chip in, right? So I'm reluctant to compare arbitration and dispute boards because they are two different creatures. And us as our attorneys, the ones that we are attorneys and also litigation, we always try to, to make this comparison. I think that the DV member who is doing the chair has a role that want to put the parties together, keep the peace within the dispute board and within the project. So I think that is a different role that what chair of arbitral tribunal does. So I think it's are two different things, just to mention.
Good.
Thank you to clarify that. And well, since we were talking about the chair, before we go in on the first tasks, what would you think would be then its main goal from the chair? I mean, what is he expected to do when he gets this task?
Well, when she gets the task,
I'm sorry.
when she gets the task, that person gets the task.
The chair.
One of the first things is definitely communication and coordination with the 3 DRB members. You want to find out, if you don't know them, sometimes you get on dispute boards with people that that you've been on other dispute boards with, but sometimes they're new people. So finding out, here we're in 3 different countries right now, and especially if you're doing an international project, where are people located? What's going to be the process of getting them together? Because we're going to be at the project site at some point. And, so you want to establish a relationship and rapport with the 3 people. And then I think the next thing is that reviewing the contract. What are the specifications for a dispute board? And if you are the chair, you have a role in developing the dispute board agreement, which is the agreement between the parties and the dispute board. You might have operating procedures. So there might be other logistical things about getting the parties together, because you want to have a dispute board agreement, because that's how the dispute board members get paid. That agreement is going to specify how much they get paid for, doing a meeting, or, whether they get additional travel expenses, or however that's going to be structured. But the chair really, wants to kind of put some of that together in the beginning, so that they can talk to the other 2 dispute board members about those logistical things and to get started. Let me pass the baton to Christian too.
I think one of the main goals, we have to think about what is the goal of the DB. As FIDIC add the new A to that, we have the avoidance. So the avoidance, for me, is the main goal of the dispute board. That comes together with prevention, of course. So what do you need as a dispute board chair or members, what do you need? What is your main goal to reach that higher goal of avoidance? Is to gain the trust of the parties, to have the parties working together as a team with the DB. So gaining this trust to the parties will help you in the future when things are not that nice, right? When people are starting to be angry to each other or they're going to start having differences, then if you gain the trust of the party since the beginning and you develop that relationship with the parties, at the time that the party asks for an informal assistance and you give an opinion, no binding opinion, the party will follow your opinion because you have that trust of the party and you've been with them through the process. So I think besides all what have been mentioned, that gaining the trust of the parties from the chair and the other members of the dispute board is very important.
I think I would reiterate definitely that big word trust, is how are you going to, as the chair, how are you going to get the other two dispute board members to trust you too? How are you going to trust each other? And then how are you going to get the parties to trust you? So that when you do issue an opinion, hopefully they're going to accept it, and they may not have a choice with the fitted contracts, but, I think the purpose, just to springboard off of that is you want to coordinate the first meeting. And a lot of times the first meeting is called a kickoff meeting. So that kickoff meeting is typically in person, but not necessarily. You need to figure out, is it going to be virtual or is it going to be in person? Because it could be virtual, especially if people are in different countries or different parts, if there's travel involved, it may be that the first meeting is virtual, but most of the time for me, it's in person. And so you want to find out, who's definitely the 3 dispute board members are going to be there. But what about, the contractor, the agency or the employer? What, who's going to be the key people that they're going to have there? A resident engineer, maybe it's the president of the company, maybe a manager, who are the key people that are going to be there? So you want to start this communication. So, who's going to, if you're going to start it via email, who are the key people that you're going to be emailing to? And so logistically finding out all that information, with how you're going to organize a kickoff meeting, developing agenda, is there going to be some training involved? If they have experience with dispute boards, if they don't, then you might want to have some training about what exactly is a dispute board. So there's a lot involved in developing the agenda that, that you want to have a buy-in with your other 2 dispute board members. As the chair, you're the one who's putting all of the ideas and information together.
Do you usually meet
if you
with the members of the DB before the first meeting? Do the DB members, they get together and they discuss a little bit about this agenda, don't they?
Yeah.
It really depends.
Mhm.
It depends.
Sorry.
Because I certainly have had some dispute board processes, some chairs that have just developed it themselves. So I don't think that's best practices. Best practices are to coordinate with each other. So that's my thought.
I agree with you, and I think this is very relevant, this kickoff meeting. And I usually do a little workshop training, however we want to call it, like, a little speech of what you expect from us and what we expect from you. What are the roles? What is the main goal of the DB, etc., etc. So that put the party inside the frame what we're going to do, and that give them a lot of answers, because many times, not always, but many times, they are not experienced in dispute boards. So this first kickoff meeting is really important to set up all these terms, all what we gonna expect on the future months to happen when you have your dispute boards with you, when are gonna be the meetings, are gonna be in person, are gonna be by Zoom or Teams or whatever. It's very important so the people know, the parties know what to expect, right? Like the book when you're expecting what to expect.
Right.
All right.
But, the other important thing for the kickoff meeting is really learning about the project. Because, as the dispute board gets the name of the project, a lot of times they will get the location of the project, the amount of the contract. But to really know and understand this project in the beginning, you really want to have, maybe it's the employer or the owner's design team that makes a presentation on what is this project. And it may
Correct.
be the contractor who's talking about schedule and, that sort of thing. But you want to, as a kickoff meeting, one of the important aspects is for the dispute board to learn about this project. So, and then the site visit,
Yeah.
I think it's very important to have a site visit so that, however big the project is, if it's one particular location, or if it's like a bridge project or a water project or highway, if it's 20 miles long, or if it's just, 1 square acre or something, to have, as part of learning about the project, to drive around the project or to walk the project, so the site visit is important for the meeting also.
Yeah, on that topic, I just got, I'm going to jump the first question here because I have a question from Nancy Brito. She said, hi to everyone, and does dispute board members get into the field to observe works development at any point of the project, or it's done only during kickoff meeting? So I guess just to clarify what you were just talking about, the site visit.
Yeah, so just to clarify, I have the
That is on the
project,
chat or is in
the contract usually defines
Q&A.
how often you're going to have site visits. But I like to have a site visit with each visit. And if it's a quarterly meeting of the dispute board at the project, as long as we're doing an in-person meeting, if you're doing it virtual, the site visit can be done by video, by photographs. It can be part of the contractor's and the owner's presentation. But for in-person meetings, definitely a site visit is every time you have an in-person meeting, which typically is quarterly. So every 3 months, you're going to the site and you're driving around the project and walking part of the project to see what's going on. And a lot of times they'll be explaining, we're having a problem with this paint spec or whatever. And then when you're out at the site, they say, they don't like the color. And so they want to change the color, and this is the paint, So you just listen and observe.
Yeah.
I think for the site visit, it's important for the DV to get familiar with all the project, the side of the project, the weather of the location, etc., etc. So at the beginning, this kick-off meeting could be at the project or cannot be at the project. Also, how often you go to the project depends of every project, because some projects are, I don't know, 1-year projects, and other projects are 5-year projects. So maybe in the 5-year projects, you need to go every 3 months, like just it's been said, or you have to go every 2 months. It depends, What is very important also is to be in constant communication with the parties. So if you do every 3 months or every 2 months site visits, it doesn't mean that you cannot do like a meeting that like we are having at this moment with the parties every month. And the parties can show you some pictures of the project, can do a drone video. You know, you have a lot of technical resources to get familiarized with the project and to get a really good communication with the parties. I'm gonna tell you something that happened to me last year in a project. The project is in an area, is in a location that rains a lot. So we have a virtual presentation, and they show pictures, and the pictures, everything was dry, no water, nothing. And I say, oh, from those pictures, it seems like it haven't been raining. And they say, what? It rains every day. The thing is really hot. So after it rains, it gets dry. So now it's very funny because in every presentation that they do, the virtual presentation, they put all the pictures when it's raining. So that is, you know, very important. The site visit is very important, and how often you agree with the party is very important. That gives you also the sense of being a team and working together, you know.
Great. We have another question here, maybe for you, Christian. It's asking, the DRB recommendations are not binding on Caltrans contract, like Elizabeth already explained when we first talked, Elizabeth. But what is the usual case in Latin America, typically on FIDIC or NEC contracts? Are the DBs here usually binding?
Okay, first of all, I want to say hello to my friend Oscar Cortez from Mexico that made that a question. Hello, Oscar. Well, the term binding, we have to be careful about that term. Are contractually binding, but it's not like a final decision from a judge or for an arbitration. We have to be careful about that. It's contractually binding. If you don't follow the decision of the DV, and if you don't go to arbitration as the clause, IDR clause states, you have to follow the decision. If you don't follow the decision, you are breaking the contract because it's a decision contractually binding, but it's not a final arbitration or a final judge decision. You know, we have to be clear about that difference, you know, and we say that you pay now and claim later, you know. So you have the idea, the whole idea of this universe of contracts like FIDIC, NEC, etc., is to get the project done. Whatever are the disputes, whatever are the claims, you have to get the project done because those contracts are made for that. I don't know if you have another opinion about it. Elizabeth?
Well, yeah, and there, and I worked on, I want to tell you, in the United States, I said, it's whoever's developing the contract. I worked on a project where all of the dispute board decisions up to $1 million in the claim were binding. And beyond that, it was advisory. So you have to just really look at what the parties put in their contract and what they've agreed to in the United States. It's not, the FIDIG is, everybody knows what the contract says because it's the same all the time. But in the United States, it's different. So you have to really be familiar with that. And as the chair, you've got to keep your fingers on that because you might be working on, 5 different dispute boards and each one has a different contract. And so you have to be able to, review those and when necessary to advise the dispute board and the parties about, particularly in the training, you know, what's involved? Are you going to have informal dispute board meetings, or are they all going to be formal where there's a written opinion? And an informal is where the dispute board gives you an oral opinion. So some contracts allow that, some contracts don't allow that. So it really depends.
And in between the site visits or meetings, it's also another question from Oscar, and I myself like to ask that. Is there any routine other meetings in between, informal with the members? Is there routine tasks from getting the daily reports, getting the letters, getting the minutes from the meetings that are going on site? It's also, does the chair has a role on that, on organizing all this documentation that it's usually produced as the job goes on?
There's a software program called SharePoint, and I have a couple of projects where they use SharePoint on the project for the contractor and the owner. They also have a section for the dispute board members. And so what are the things that get put on SharePoint for the dispute board members to review? You know, it could be not only just the dispute board agreement, the operating procedures, but it might be certain minutes of meetings between the owner and the contractor, which occur, maybe it's a monthly meeting, it might be a weekly meeting. And so sometimes there's updated information that the dispute board members can review beforehand, but not all projects do that. And it might be that there really isn't, you don't do anything in between the meetings until you get to the next meeting, and then all of a sudden you get all this information.
Okay, I have a comment there. And my comment is, you go with the flow. What that means? It depends, you know. Maybe we have a side meeting, and in that side meeting, we talk about something that maybe the parties don't have the information that day, but it's something that you see as a chair of the dispute board important to prevent or avoid any dispute of the party. And maybe you can say, well, why don't you look about that information and let's put a meeting in a week, a virtual meeting, or in 2 weeks. You send the information to the parties and to the DAP before, so we can review the information, and then we talk about it. And we put 2 hours to talk about it, you know, and it's like that, you know, it depends on what is happening through the process of the works. So that's why it's very important, and we cannot emphasize more this, that the dispute board is a standing dispute board since the beginning of the project. So that gives you the tool and the opportunity to work with the party and try to go with the flow. What happening is what you do, right? So that's my comment about it.
You know, I wanted to just in the Q&A, Oscar and hello has kind of a couple of questions regarding the informal and the formal, and I wanted to just clarify that. The informal is informal dispute process is a method that's used typically during the regular quarterly meeting, where the parties have put together, there's a dispute and they would like to get the opinion of the dispute board. So they put together a very short paper with, you know, the reference documents. It might be contract or spec or whatever, but it's a very brief thing. Might be a page, no more than 3 pages long. And the dispute board hears the parties present on this issue, and then they go to a different room, discuss it, and come back and give an oral opinion. That's an informal dispute process. The formal process is where the parties want, they have an actual dispute. They want to have a formal hearing. They want the dispute board, they want to be able to present their written documents and their supporting contract documents And then the dispute board will listen to the parties, and it could be at a regular meeting or it could be a separately scheduled meeting. And then the dispute board actually takes everything, they go away, they discuss the process. The chair usually starts the ball rolling with developing a formal written opinion, and it might be divided to different sections. Somebody's going to do the damages, somebody else going to do the contract terms, somebody's going to do the facts. So it might be divided up as far as writing. There is a formal written document that is developed, and that is usually due within 30 days, but you have to read the contract to figure out what are the requirements for writing that formal written opinion. And then that formal written opinion is distributed to the parties. So those are kind of, just to clarify the difference between the informal and the formal BRB process. I hope that helpful.
And I have a question on that. And when you submit your opinions, and one question is, like, either formal or informal, can they be challenged, and can the review their opinion by the challenge of the parties of even like a formal opinion that's issued?
So I'll just give you my quick response, and Christian, from your experience too, would be great. The informal is, and again, you need to look at the contract, but the informal and the formal typically in the United States is advisory, and it's non-binding. After people doing an informal process, they actually can have a formal hearing on the same issue if they don't agree. If the parties meet and they say, we think the dispute board missed the point, let's do a formal hearing. Both parties have to agree to come to the table to ask the dispute board to do an informal hearing, but only one party has to do it for the formal hearing. So it may be that one party disagrees with what the dispute board came up with. But, you know, I'm in the United States, you know, you have maybe some opinions are binding depending upon the contract, and everything else is advisory, which is very different than fitting. And I know you talked about this a little bit beforehand, but maybe you could re-explain in the fitting contracts the bindingness of the formal written opinion.
Yeah, well, challenge the decision is not, let's say, the way to say it, because it's not challenged. You have steps of alternative dispute resolution. If you're not, if you are not in agreement with the decision, you go to arbitration or you go to court, depending on what the contract says. But it's the dispute board doesn't have a superior, like you have a normal judge and then you have the appealing judge. No, we don't have that. You know, it's steps in a ADR process. So from my point of view, are not challenged, is that they are binding. If you don't go to the next step of the ADR process, contractually binding, those are the decisions. And the informal opinions of the DV are not binding at all. But I go back then to my previous comments of how to gain the trust of the parties. If you gain the trust of the parties and you are doing a good job going to the side meetings, meeting the parties, talking to them, you know, at the end of the day, if they have that and you give an informal opinion, which is not binding, most of the time helps them or negotiate to each other or talk or follow that informal opinion, because they say, well, this dispute board are part of our team, we're working together, we ask them, and they say, well, you should go through this way. So that's what I think about it.
Oh.
You know, one technique that has been used is that the parties can present issues and even present written papers on an issue. And the dispute board does not render any opinions. The only thing they can do is ask questions.
Mhm.
So a lot can be said about the way somebody asks a question or
Yeah.
what
The
they
way
ask
that Dibius,
to get the parties
the way that dispute board asks the
agreement themselves.
questions.
Yeah, and it forces the parties. They want to know what you think as a dispute board, but they don't want your opinion. And so the only thing you can do is ask questions. But the questions you ask and the way you ask them gives the parties information about how you would rule. And
Correct.
it's been very effective in getting the parties to continue negotiations and agree.
Well,
I have like 3 experiences in hearings that in the middle of the hearings, the parties say, hey, would you please give us a minute? And they go to another room to negotiate and settle. It
Yeah.
was very interesting. It's because, as Elizabeth said, when you start asking questions and you're repeatedly asking some kind of questions, of course the party knows what you want to know, what you're looking for. So sometimes they say, let's better negotiate and settle this, So that is a great technique, and it's happened to me, and it's very interesting. It's nice to have that.
Well, when you have an opinion, informal or formal, I believe that the best case scenario would be to have a unanimous opinion from the 3 members of the DB. Is that would be also a role of the chair to stimulate, the conversation and the analysis and the talking to see if all of the members, if they get to the same opinion or of the same conclusion in the matters that are on dispute.
It's really the goal to have the 3 members have come away with the same opinion. There can be a written dissenting opinion, but if you have that, does it really, service the parties? They're in dispute, and if you have the dispute board members disagreeing too, it just reaffirms, the parties have valid arguments on both sides. I think the chair, really one of the important aspects is to keep the dispute board members talking. Why are you feeling this way? What is the contract term that you're looking at? And what about this? And, keep talking and try to reach some unanimous consensus with respect to the issue. So I think that's really important to do.
Yeah, I agree. That should be the best scenario.
And I would like to hear from you as well, just since we're getting to the final minutes, and I also encouraged our audience, if anyone has any final questions for us to submit here to Elizabeth and Christian, but what to do? We already talked about what to do. Is there any thoughts of what not to do as a chair or a DB member that you would like to list out as well?
I'll tell you what I think is really important not to do is have individual conversations with the contractor or the owner. You have to be above board and really establish, a process that there's no ex parte communications, even with the chair. Now, there might be certain things like logistics, like, a conflict, somebody's sick, or there might be, some logistics issue that comes up that you have a private conversation with, or an private email. I mean, even private emails, I think should be sent to everybody. If it's between the dispute board, then the 3 members should all be copied. The chair shouldn't be speaking with one of the other dispute board members, even if they've known each other for 30 years. and the third dispute board member, you just met. There shouldn't be individual conversations regarding that project. They should all be included in. So I think that's really important. Ethics.
Yeah, the ethics is all about the trust, so the ethics comes together with that. For me are the lawyers. The chair and the DB needs to model the communication within the process of the DB, so the attorneys don't turn the meetings or all the communication that we have between the parties into a trial, because this is not a trial, so it's very important to set the role of the attorneys in the dispute board process, because the attorneys can help a lot, a huge help can give it to the project if they are in a collaborative way of advising their parties. But if they are in a litigation way to advising these parties, it's going to be difficult for everybody. So it's very important to set up the collaborative role of the attorneys in this process. This is
That's
kind
great.
of difficult sometimes.
Yeah. Well, like I said, today's our last panel. It's going to be in YouTube, I believe that, and can also put on the link, and the other 5 that happened before ours will also be available. And I've learned a lot today here in Brazil. It's really getting started. We have some DBs going on, but I believe that's a lot of room to grow. And I would like to thank you, Elizabeth and Christian, for sharing your experience and knowledge with us here tonight. And we have here, less 3 to 2 minutes. If you'd like, Elizabeth, say your final words and goodbye to everyone, and Christian after.
Okay.
From
I
my side,
to
thank you very much.
I wanted to just mention Robert Sedano just put something in the chat. He goes, what do you do if all 3 members of the DRB are of the dispute board are lawyers without technical knowledge of the facts surrounding the issue? And it's been my experience that lawyers that are committed to the dispute board process have a lot of background in construction. And granted, everybody's experience is different, but typically I have never met a technical issue that I couldn't understand. It may take me a little bit longer to get the lingo or, down, but understanding the technical issues, maybe because I come from a design background, maybe because I've spent 40 years working in the construction industry. But I always find that, everybody has diversified knowledge and we all have to help each other. So it's been a great process, and it's really nice to meet both of you and participate in this webinar. Thank you.
Okay, first of all, I want to thank you all to be here with us. Thank you, Elizabeth, Jem, and Anne for the opportunity, and also Felipe that is not here, but for the opportunity to be in one of these webinars. The series called Awareness. So I hope this helps all of us to be aware of what a dispute board can add value to our countries, not just to the contracts and not just to the parties, but to the countries, because one driver of the development of one country is, like I said, infrastructure. So if we have good roads, we have good ports, airports, blah, 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 hospitals, education, facilities, etc. We can add value to our country and get our countries developed more. So this is a perfect tool to get that done. So I think if you take these awareness programs of 6 sessions, for that, our job is well done. Thank you.
Fantastic. Thank you.
Pura
Yeah,
vida.
great
We say in
words.
Costa Rica, pura vida.
All right. Well, take
Thank you
care,
very much.
and I'll see you guys
Okay.
all soon.
Bye, everybody.
Thank you.
Thank you for coming.
Bye-bye. Thank you, Anne.